If you're a real estate agent or a landlord and you're listing rental properties, this video is for you. My name is Danielle Ohlms and I'm the broker and owner of Keyrenter St. Property Management. This is my final video in my 5-part series, Everything You Need to Know About Rentals from Marketing to Move In. And today I'm going to go over 5 really huge legal mistakes and what you can do to avoid them. The first big mistake I see landlords and real estate agents making is not understanding emotional support animals, or ESAs, and service animals. Even if you have a strict no pet policy, you cannot deny an ESA or a service animal. You cannot charge a pet deposit. You cannot charge any type of pet fees. So what can you do? You can verify an ESA by requiring the tenant provide a letter from their doctor. You can require the tenant sign your animal agreement, which should outline all the expectations of taking care of the animal, and you can hold the tenant accountable for damage from the animal. If you deny an ESA or service animal, the tenant can file a complaint with HUD. This is not something you should just wing it on. Learn the laws. Another huge mistake is not having established rental screening criteria. This is most definitely not something to just figure out as you go, because denied applications are one of the most common fair housing complaints that people make. Set all of your criteria up front and be specific. Name a minimum credit score and any other immediate grounds for denial, like recent evictions, foreclosures, negative landlord references, things like that, and treat everyone the exact same. Third, you can't just collect any amount of security deposit. Each state law is different, but Missouri only allows up to 2 times the amount of the rent to be collected as a security deposit. So this means that if your rent is $2,000 a month, your max security deposit you can collect is $4,000. And fourth, while we are on the subject of security deposits, in Missouri, you must return the deposit within 30 days of the lease ending. If you're deducting anything from the deposit, you also must include that itemization breakdown within 30 days. And another thing to know about the move out is that the tenants have the right to be present at your move out walkthrough. So you must notify them when you'll be there. Many other states don't have this law, but Missouri does. And last, be extremely thorough in your move-in documentation. One of the most common landlord-tenant disputes is over the eventual return of the security deposit. If you wind up in court, you're going to need to be able to show the previous condition of the properties. So, for example, say the tenants had a dog and the dog completely chewed up some baseboards. Well, how do you prove it wasn't already like that when the tenant moved in? You have to have documentation showing the prior condition, which means lots of videos and lots of photos. Know the laws before you rent. It's important. This wraps up my 5-part video series, Everything You Need to Know About Rentals from Marketing to Move In. If you haven't watched the other videos, be sure to check them out. There's a lot of good information in those. And as always, I am here to help. Give me a call, 636-707-2000, or visit our website, KeyrenterSt.com.